I will start this presentation with the definition of transnational audit. A transnational audit is an audit of financial statements which are or may be relied upon outside the audited entity's home jurisdiction for the purpose of significant lending, investment, or regulatory decisions. This will include audits of all financial statements of companies with listed equity or debt and other public interest entities which attract public attention because of their size, product, or services provided. For the implications, the Dragon Group is traded on the stock exchange of various nations and it intends to list again to raise additional funds. This implies that the group is bound by listing regulations outside of its native country and is subject to the rules of all stock exchange on which it is listed. The group also has a large number of international subsidiaries, which indicates that it does business in a global financial and business context. Next, we will move on to the transnational audit and audit risk. Firstly, applications of auditing standard. Even though many countries have embraced international standard on auditing (ISAs), some have elected to utilize independently created auditing legislation. Additionally, several nations employ altered ISAs. In a global audit, this means that some parts of the group's financial statement will have been examined using a different auditing framework, leading to uneven audit procedures throughout the organizations and perhaps lowering the audit's overall quality. Next, regulations and oversights of auditors. There are numerous methods that the operations of auditors are regulated and observed around the world, much like the previous remarks regarding the usage of ISAs. While the audit profession uses a more legislative approach in certain nations, it follows self-regulations in others. This may also have an effect on the quality of the audit job in a global setting. Other than that, financial reporting framework. International financial reporting standards are used in some countries, while domestically created accounting standards are used in others. To meet the requirements of the countries relevant to the group financial statements, often the jurisdictions of the parent company, adjustment, reconciliations, or restatement within a multinational group may be necessary. Such reconciliations can be difficult and need both the provider and the auditor to have high level of technical knowledge. Lastly, corporate governance requirements and consequent control risks. There are several countries with the highly strict corporate governance law that the auditor must consider during the auditing process. In these situations, the auditor might need to go above and beyond what is required locally to ensure that the group as a whole complies with the regulations of the jurisdictions that have an interest in the financial statement. However, there are certain nations with practically no corporate governance regulations, meaning that control they are probably weaker than in other parts of the group. Therefore, control risks may vary between the numerous subsidiaries that make up the group.
Thank you, Natasha. Hi, and Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Aisyah. In this part, we will discuss the form of FOF. What is FOF and how it is related to the transnational audit? FOF is an association of international network of accounting firms that perform transnational audits. The objective of FOF is to promote consistent and high-quality standard of financial reporting and auditing practice worldwide. The forum gathers firms that perform transnational audits and involve them with the activities of the International Federation of Accountants (IFAC) in audit and other insurance-related areas. There are many members of FOF, such as Big Four accounting firm, consists of Ernst & Young, Deloitte, KPMG Internationals, and PwC, Orange, and Nexia Internationals. For your information, there are few obligations that the members of FOF need to obey. Firstly, they need to maintain appropriate quality control standard in accordance with the International Standard on Quality Control issued by the International Auditing and Insurance Standard Boards. Next, conduct to the extent not prohibited by national regulation, regular globally coordinated internal quality assurance reviews. Besides that, FOF have policies and methodologies for the conduct of such audits that are based to the extent practicable of ISA. FOF also has policies and methodologies which conform to the International Ethics Standard Board for Accountants Code of Ethics for Professional Accountants and National Codes of Ethics. Lastly, members must agree to submit to the Secretary of the firm an annual report in a form approved by the TAC, indicating that they meet the membership obligation set forth above.
Next is the Transnational Auditors Committee. TAC is the executive arm of the forum. Therefore, it provides the official linkage between the forum and IFAC. They are responsible for the execution and progress of FOF priorities and operations. They also play a major role in motivating the members of the FOF to perform high-quality international audits by requiring them to be committed to complying as a condition of a member with international standard. The TAC also support audit quality by identifying audit practice issues and making recommendations to the appropriate standard setting boards to review this issue as needed. Other than that, they also provide a forum to discuss best practices in areas including quality control, auditing, independence, training, and continuing professional development. Next, TAC facilitates interaction among transnational firms, international regulators, and financial institutions with regard to audit quality system of quality control and transparency of international networks. Lastly, identifying qualified candidates to serve on the international standard setting board. Moving on to multilingual barriers in performing transnational audit. Good communication is essential when performing work, especially in conducting audits. In a transnational audit, parent companies need to rely upon the information related to all financial statements gained from subsidiaries or associates that are operating abroad. There are approximately 7,100 languages currently spoken all around the world. Not all professional auditors are translinguistic, so they may encounter some problems when performing audits. The auditors are required to understand the context of the financial statement in completing the audit process, regardless of the language used, to give a true and fair view of the financial statement. The element of language may be different in every language and will make it difficult for auditors to understand and interpret the audit report. There are four elements of the language, which are semantics, pragmatics, stylistic, and syntax. The first element is semantics. It refers to the meaning of the words in a language and a sentence without considering the context, and it does not account for any implied meaning. There are some issues with translinguistic profession because each country has different conceptual objects of accounting as taught and practiced in their respective country. The auditors will be confused or will not understand the financial statement because each country may have differences in institutional setting and social function of accounting, and their metaphors may not be shared across linguistic cultures. As for pragmatic, it is similar to semantics, except it is also within the context. In each situation, the various listeners in the conversation and environment define the ultimate meaning of the words based on the other clues that link subtext to the meaning. Pragmatic failure may be divided into pragmalinguistic and socio-pragmatic categories. Firstly, pragmalinguistic failure issue may be due to the auditor or translator making an erroneous assumption that the expression used for a particular function in his or her mother tongue is directly translatable into the foreign language. For example, an Italian translating the word fatturato in an income statement into English for invoice rather than by actual meaning is sales. As for socio-pragmatic issues, they may occur in cases where the translation is accurate enough, but the form of expression used in the source language is inappropriate given the different mores of the country in which the target language is spoken. To illustrate, the style of a typical Belgian audit report may strike British readers as flowery and ingratiating to the point that the auditor's impartiality may be questioned. The third element of language is stylistic. Stylistic is concerned with particular choices made by individuals and groups in their usage of language. Sometimes, the auditor or translator employed make wrong choices in selecting the meaning of the word. It can happen as sometimes one term of a word can have different meaning. Thus, they need to know the financial calculation and financial statement to translate all the terms given. It is to avoid any misinterpretation that will cause problems in the future. Lastly is synthetic. Synthetic considers the internal relationship of elements within utterance that are crucial to their significance. Auditor or translator employed needs to understand and relate the terms used in the financial statements to overseas companies with the accounting policies. If they cannot relate it to the accounting policies, there will be problems in the future. This is because they need to ensure which accounting policies and terms are being used in the financial statement. It is not difficult for a translator to translate the financial statements that need to be audited. However, it is difficult for them to translate it into the context of accounting policies on audit report. They need to know the accounting profession, business activities, culture, and regulation of the country in which they operate. The auditors need to have a deeper understanding of both financial statement and audit reports to avoid giving a misinterpretation opinion in the audit reports.
Moving on to the next issue, I will explain about the regulation of cross-border audits of the NPOs, a legitimacy perspective. The article we chose provides an argument for greater regulation so that the audits can be more effectively determined if development assistance was used as intended by drawing on conception of accountability and legitimacy. The NPO is stand for Development Not-for-Profit Organisation. In such audit, the customer is typically a program DNPO in a high-income nation that contracted with one or more field DNPOs in the recipient company to carry out the development work after receiving funding from government agency or grant-giving DNPO. The auditor audit the field DNPO in the recipient country and report to the client in the high-income country. The client is given the option to choose the audit framework because of the applicable international auditing standard for the project account of individual development projects. Furthermore, the client has financial and reputational motive to prioritize fulfilling its own responsibility to its contributor. As a result, the client can be driven to define an undemanding framework in order to obtain a favorable audit judgment. Limiting the audit framework to issue a bookkeeping correctness is one way for the client to guarantee that a clear audit opinion is reached. It can be deduced from some of the caution against it that this is a problem with some practical consequences. The complex demand placed on the international audit of field, the NPOs are well known to the legitimacy community of development.
Next, the application of transnational audit. For a short brief, this article is about the collapse of Rana Plaza building. It was constructed as a 6-floor building in 2006 in Bangladesh. But in 2013, the owner of the Rana Plaza decided to expand the building to the 9th floor. However, on 4th April 2013, the building collapsed during the construction of the 9th floor and resulted in a total of 2,250 injuries and a death of 1,130, including 39 children aged from 13 to 70 years old. The day before the accident, there were cracks at the structural pillar of the building, and it caused an evacuation order by the police for the safety and inspection by a local engineer. But after the inspection, the owner announced that the building was safe for operation on the morning of the accident. After the investigation, we obtained that the collapse was because of the building structure, which was constructed on a drainage pool. This violated the building codes, which did not get an appropriate approval. According to the engineer, the factor that triggered the collapse of Rana Plaza is because of the large vibration from the diesel generator used due to power outage during the day of the accident. There are 5 garment manufacturers operating in the Rana Plaza, but unfortunately, 2 out of 5 manufacturers, which are New Wave and Phantom April, were involved in a various transnational complaint and litigation proceedings. New Wave, which is a subcontractor of Pearl Global, was assigned to produce garments for law that abide CSR standards. Due to that, in February 2011 and April 2012, New Wave has been audited by social auditor from Bureau Veritas. Meanwhile, in June 2012, Phantom April was audited by a different organization, which is TUV Greenland's Indian subsidiary company. The building owner, manufacturing company owner, and government agencies are subject to public interest litigation and criminal procedure in Bangladesh courts, while Bureau Veritas and TUV Greenland have been held accountable for their role as an auditor that led to the collapse of Rana Plaza. The European Centre for Constitutional and Human Rights, ECCHR, Activist Anthropologists Bangladesh, Clean Clothes Campaign and Medical International filed a complaint to the BSCI, which is Business Social Complaint Initiative, in July 2015 regarding the audit performed by TUV Greenland India Pvt Ltd. The complaints is due to the negligence of TUV Greenland in identifying non-compliance of BSCI code, which consists of the absence of legitimate building license, the dangers to the structural integrity of the buildings, the irregular documentation of workers' registration, the use of children as laborers, the workers' lack of knowledge of their legal rights, and the absence of the BSCI grievance mechanisms. The managing director of BSCI indicated that the auditor was not tasked with examining the structural integrity of manufacturing facilities, but rather was solely given the task of looking into the flaw issue. Due to unsuccessful complaint earlier to BSCI, the ECCHR and German National Contact Point (NCP) filed a complaint against TUV Greenland, which violated the OECD's guideline for multinational enterprise. The complaint is regarding the failure of TUV Greenland in fulfilling his duties to take into consideration the governance context in Bangladesh. In response to this concern, TUV Greenland once more said that the structural study of a building is outside the scope of its social auditor's training and is not meant to be a part of the BSCI audit. According to the NCP, TUV Greenland is found not guilty because there is no sufficient evidence that indicates the careless and false statement of the structural integrity of the Rana Plaza. Based on the article, there is another lawsuit in the Ontario Superior Court of Justice against Law and Bureau Veritas, who had been auditing New Wave before the collapse by the 3 survivors and a family member of a deceased worker in Rana Plaza. Next, the plaintiff contended that both Bureau Veritas and Law had breached their respective duties of care by failing to include obvious risks to the structural integrity of the Rana Plaza facilities in their respective audits and by declining to engage Bureau Veritas to conduct a more thorough audit. The manager of Bureau Veritas' Social Accountability Division stated that his company was hired to conduct an audit of New Wave's workplace policies regarding occupational health and safety and employment, but there is no obligation and requirement in the contract that stated the needs of inspection of the building's structural integrity. In conclusions, the court ruled in favor of the defendants, finding that the company lacked the control over New Wave to compel change to its operation, the control to initiate follow-up inspection resulting from the absence of documentation of an operating lessee, or a special relationship between the plaintiff to create a duty of care.
Next, from the same article, there is also another application, which is the Ali Enterprise building fire. In summary, the fire at the Ali Enterprise facility in Pakistan, which claimed 289 lives and injured hundreds more, was the deadliest factory fire in the history of the contemporary clothing industry. In addition, it was Pakistan's deadliest industrial disaster ever. Just 3 weeks had passed since Social Accountability International signed a multi-stakeholder initiative (MSI) that specialized in certifying conformity with its own SA 8000 standard had visited the factory with inspectors. The Ali Enterprise facility was deemed safe by site monitors despite the fact that it contained severe safety risks, including a dearth of functional fire exits that ultimately result in the death of close to 300 workers. On September 12, 2012, a boiler explosion within the plant is believed to have caused the fire, which spread fast throughout the structure. The main exit of the plant had been closed as the workers tried to flee, indicating that the supervisors were more concerned with preserving the inventory than the lives of the employees. Because of this, only one exit was available for the more over 600 employees that were inside at the time, and about half of them did not escape in time. Because the plant lacked the necessary fire exits that would have stopped the deadly smoke from spreading throughout the structure, many of the workers who died as a result of smoke inhalation. The issue was made worse by bars on the windows, insufficient fire safety gear, and lack of fire safety training for the workers. 2 investigators from the RINA Group, an Italian company, so engaged to conduct the examination, spent several days at the facility in the weeks preceding the fire. Ali Enterprise was subsequently awarded a SA 8000 accreditation by SAI, demonstrating compliance with standard in 8 different categories, including health and safety. One of the most extreme examples of how corporate-driven MSIs fail to uphold workers' rights was the SAI's certification of this factory as safe in spite of blatant and evident safety infractions that results to workers' fatalities.
In conclusion, all the issues arise have met to solve it. For example, the athletic component audited that arise from cross-border group audit in hidden costs can be solved by assigning group auditors that have both global and locally agility. This is because the audit group need to respond quickly to the issue without any delay to avoid any risk. The software used by the company also important, which require company to use high-quality software where the audit can be shared internationally without the need to travel globally. Besides that, the development of non-profit organization, also known as the NPO, also have an issue. The audit in the cross-border in the NPO have a hard question where the auditors need to acknowledge the complexity. Auditors also need to focus on the improvement of accountability and legitimacy by referring to general accounting rules and specific regulation. They also need to establish and regulate the new scope of financial auditing to focus on the beneficiaries' claim, which is their key motivation for their development program. Lastly, this shows that the audit process might be less proper and develop practice when there are variety of client audits and contact. Therefore, both company and the group audit need to cooperate with each other to produce a high-quality audit report to perform the transnational audit effectively.